A Guide to Ontario Standard Lease. This guide contains information on rental rules and rights and responsibilities of landlords and tenants under the Residential Tenancies Act. Background. The Standard Government of Ontario lease has been used for most residential tenancy agreements signed since April 30, 2018. Prior to that time, landlords would create their own lease agreement, often containing conditions, charges, and rules that were contrary to the Residential Tenancies Act, the RTA. A lease cannot take away a right or responsibility under the RTA. The Standard Government of Ontario lease ensures that all rental agreements are generic and comply with all Residential Tenancies Act requirements. Update. The standard lease has changed, and now for most new residential tenancy agreements signed on or after March 1, 2021, you must use the updated standard lease. The standard lease does not apply to care homes, sites in mobile home parks and land lease communities, social and supportive housing, and certain other special tenancies including co-op housing. What is in the standard lease? 1. Parties to the agreement. This section has the names of the landlords and tenants who are agreeing to the tenancy. 2. Rental unit. This section describes the rental unit that is being rented and the address, the number of parking spaces, and their location. If the rental unit is in a condominium, it should be indicated in this section. 3. Contact information. This section has the landlord's address where notices must be sent. If a tenant needs to give a formal notice to the landlord, it should be delivered to this address. This section also allows the landlord and tenant to agree to receive formal notices by emails and includes a space for both the landlord and the tenant's email addresses. Formal notices can only be given by email when allowed by the Landlord-Tenant Board rules. This section also includes a place for the landlord to provide additional contact information for emergencies or day-to-day communication. 4. Term of tenancy agreement. This section has the date that the tenant will have the right to move into the rental unit and the length of time, term, of the tenancy. 5. Rent. This section sets out the total rent, also called the lawful rent. The total rent is the total of the amounts in subsection 5(b), which includes the base rent for the rental unit and any separate charges or other services, such as storage locker or air conditioning, that the landlord provides to the tenant. Any future rent increase will be based on the total rent in subsection 5(b). This section also includes when the rent must be paid, to whom it must be paid, what methods will be used for payment. 6. Services and utilities. This section sets out what services are included or not included in the total rent, lawful rent. This includes both the services that are included in the base rent and services for which the landlord has set out a separate charge. In this section, the landlord and tenant also agree on who is responsible for utilities, electricity, heat, water, at the rental unit. 7. Rent discounts. This section allows a landlord to offer a rent discount. After the rent discount ends, the tenant must pay the total rent, lawful rent, agreed to in section 5, plus any lawful increases. 8. Rent deposit. In this section, the landlord and tenant agree whether a rent deposit is required and the amount. The law limits the amount and how it is to be treated. A rent deposit cannot be used as a damage deposit. 9. Key deposit. In this section, the landlord and tenant agree whether a key deposit is required and the amount. The law limits the amount and how it is to be treated. 10. Smoking. Under provincial law, smoking is not allowed in any indoor common areas of the building outside of the rental unit. In this section, a landlord and tenant can agree to rules about smoking in the rental unit. 11. Tenants Insurance. In this section, a landlord and tenant can agree on whether the tenant must have liability insurance. If the landlord asks for proof of coverage, the tenant must provide it. 12. Changes to the rental unit. This section explains that the tenant can install decorative items, such as pictures or window coverings, but that they must have the landlord's permission to make other changes to the rental unit. This section cannot be changed. If the landlord and tenant wish to agree to additional details, these can be written out as additional terms in section 15. 13. Maintenance and repairs. This section explains that the landlord must maintain the rental unit and property, but the tenant must repair or pay for any undue damage caused by the tenant or their guests. The tenant is responsible for keeping the unit clean unless the landlord agreed to do so. 14. Assignment and subletting. This section explains that the tenant needs the landlord's permission to assign or sublet the unit to someone else and that the landlord cannot arbitrarily or unreasonably withhold consent. 15. Additional items. The landlord and tenant can agree to additional terms that are specified to the tenancy. These additional terms should be written in plain language and clearly set out what the landlord or tenant must or must not do to comply with the term. If typed, the additional terms should be in a font size that is at least 10 points. Additional terms may set out rules that are very specific to the rental unit or property, such as rules about the use of common spaces or amenities. Any extra term which attempts to take away a right or responsibility under the Act is void, not valid or legally binding, and cannot be enforced. Some examples of void and unenforceable terms include those that do not allow pets. However, the landlord can require the tenant to comply with condominium rules, which may prohibit certain pets. Do not allow guests, roommates, or any additional occupants. Require the tenant to pay deposits, fees, or penalties that are not permitted under the Act, example, damages or pet deposits, interest on rent arrears. Require the tenant to pay for all or part of the repairs that are the responsibility of the landlord. The landlord and tenant may want to get legal advice before agreeing to any additional terms. 16. Changes to this agreement. This section explains that any changes to the agreement must be agreed to in writing. 17. Signatures. In this section, the landlord and the tenant indicate that they agree to follow the terms of the agreement. If there is more than one tenant, each tenant is responsible for all tenant obligations, including the full amount of rent. All landlords and tenants listed in Section 1, parties to the agreement, must sign this section. The landlords or tenants can sign the lease electronically if they both agree. The landlord must give a copy of the agreement to the tenant within 21 days after the tenant signs it.